His expertise covers a wide range of areas, including intellectual property, ICT, cybercrime, data protection, licensing, and consumer protection. He's played he has played a pivotal role in drafting laws in several countries, and his focus is on intellectual property rights for innovation and economic progress is truly commendable.
Following up, we have Mr. Kato Magola Latif, a seasoned corporate and commercial lawyer and co-founder of Magola and Molding Associates and Solicitors, LLP. Mr. Kato's journey in the legal field has been marked by overcoming numerous challenges that are typical of startups. Despite limited resources, lack of experience, and high risk, Kato and his team persevered and emerged stronger. Their commitment to their mission and vision has kept them on track, providing valuable legal services to their clients.
Our final speaker is Dr. Pankaj Kumar, a DPIIT IPR Chair Professor at National Law University and Judicial Academy. With an extensive background in the world of intellectual property, Dr. Pankaj is a registered patent and trademark attorney and an IPR facilitator. His academic journey includes a PhD in biotechnological patents, a master's in law, and an advanced master's program in information science. Dr. Pankaj's expertise and experience in the field of IPR is truly exceptional, making him a valuable resource in the realm of intellectual property.
We are grateful for all of your presence and eagerly anticipate your valuable insights and contributions to today's conference. We would also like to inform all of you that the HR team is conducting calls in the chat box throughout the session. We do encourage active participation from all the attendees. Once again, we thank you all for joining us today. So let's welcome the first speaker of the day, Mr. Richard. I would like to request him to please commence his speech.
Thank you for your introduction. I hope that everybody can hear me. I'm very flattered about your presentation of myself, and I will try to give you some insight and some views from someone coming from France, from the EU, and having helped lots of companies, including lots of startups, and what I also call the start down, because as you know, lots of startup never do not last very long and ends up as a company in bankruptcy proceeding. So let's be optimistic and try to save more startup and to help more people to grow in the future. The first thing I can tell you, which is beyond IP, is that as a lawyer, I can, let's say, more or less easily tell during the first meeting if a startup is going to be successful or not, because everybody wants to be a GAFAM, to be Google, to be Microsoft, but in fact, there are 10 companies in the world, 5 Chinese, 5 American, who really succeeded. Lots of others succeeded more or less. And you have thousands, tens of thousands of startup companies who succeed a little bit. And why did they succeed a little bit? Because some of them do not have a scope of activity which is big enough. Sometimes you see companies during the first meeting or founders during the first meeting, and you wonder, okay, they are going to make their first 10,000 euros as turnover, and after that it will be finished, because there is no market. You need to have a market, and you need to have a market which is a market which may be profitable, where you can make a margin. The second point, which is important, is that lots of startup creators do not understand that being a company doesn't mean to raise money, because lots of people think that it's enough to raise money and to spend money and to burn money. But if you are a company, if you want to survive, you need to make money and to have a real turnover and to make a profit. And this is not always understood by the startup creator, and that, let's say, goes beyond IP. Now, will IP makes a difference? No. If you don't have a market, if you cannot have a profitable business, no, IP will not assist you. It will assist you, it will help you if you have something which is reliable. And it will help you. Why and how? First, it will help you because, at least I'm speaking for the European companies, more and more the investors are looking at the existence or the possibility of an IP in the company. And this is a kind of, let's say, intellectual safety or security. I'm not speaking about a legal one, but if there are some IP, people think, rightly or wrongly, that the company can survive. The second reason why IP may help you is the normal use of IP, which is the fact that it can help you to defend yourself against infringers and to protect your market. However, be careful, because I'm speaking about something which is totally true from a legal point of view, but not from a practical point of view. From a practical point of view, if you need to defend your IP, you need to have the cash to do it, because defending your IP can be costly, especially if you have to defend it, and I will come back to that, internationally. So therefore, it is a necessary condition to become a successful startup. It is not a sufficient condition to be sure to be a successful startup. Now, what should you do if you create a startup? You need to include IP in your reasoning, in your plan, in your business plan from the start. Do not say, okay, I have more things to do. I need to find some spaces. I need to find some employees. I need to find some money, and so on and so forth, which is absolutely true. But IP is not something which should be forgotten at the beginning. Why? Because after that, it's too late, for very often for legal reason, because the IP you try to protect later on can be declared invalid because it is not considered as new anymore. And a competitor can tell you, oh, that's very interesting, but you disclose your IP before protecting it. And that's especially true for patent and also for design. And therefore, I mean, we are asking the court, whatever court is competent, to invalidate your IP. And therefore, it should be in your reasoning, in your thinking, in your plan from the start. You also should know, according to where you went to practice, when you went to your activity, where your infringers will come from. If you stay, let's say, in a part of India, if in a state of India, it is one thing. If you want to leave India and expand yourself in Europe, in the US, in Japan, in China, and so on and so forth, it is another thing. You need, I do not say that you need to think big, but if you want to think big for the development of your company, you need to think big in relation with the protection of your IP. You even need to think bigger, because you may not want to have an activity in China or in Korea, but your infringers may come from those countries or from other countries in the world, and you need to protect yourself not only in the countries where you are going to be active, but in the countries where your infringers may come from. And that depends, it's on a case-by-case basis. I'm not saying that there is or there are countries where you need to be protected. It can be different according to the type of activities you have or you will have. Next point is, I'm a lawyer, and I can tell you, you have lawyers and lawyers. You have good lawyers, you have less good lawyers, even bad lawyers. They exist. And you need to find a good advisor who is reliable. And the person, the lawyer who will assist you in order to create your company may be very good in company law, in corporate, as we say, and may be totally useless when it comes from IP. And the reverse is true, obviously. So you need to find someone who has some knowledge, who has a real knowledge, and also, if you want to be international, someone who has a network, because you will need some lawyers in other countries. And once again, you will need reliable lawyers. And if you have a good lawyer in your country, you may have a chance that he has some good connection. If you start with someone who has no, let's say, experience, no knowledge in your own country, the chance is that he may find some good connection. Being able to practice IP in other countries is obviously less certain. So another thing which I've seen a lot is that in the business plan, I'm not speaking for Indian companies, I'm speaking for French companies. In the business plan of the startup, very often when you see a line which is called legal cost, the legal cost equates the cost of creation of the company, period. No, you as a startup, you need to think about the cost of creating your IP, I mean, protecting your IP, I mean, filing your IP, and being able to protect your IP. And this is costly, especially if you want to have a patent protection. Now, you need to be aware, and that's not obvious for everybody. I'm not speaking for the attendees here because I do not know you, but I'm speaking about by experience. It is not obvious for people when they see, or you are going to spend $100,000 in order to protect your patent. They do not realize that they are going to spend $100,000, but in several years, not immediately. There is a timeline to take into consideration too. And that's very important in your business plan and in your mind. You may need $10,000 today and another $30,000 in 18 months and another, let's say, $30,000 perhaps in another 2 years later on. So, and that's how you need to think and to include that into your business plan. And you do not have to be afraid of those costs because they look, when you start, they look awfully high, but that's the cost of trying to be international. If you are not ready to spend that money, don't play, period. And how you will find that money, that's another issue, which is very important, but that I'm not going to discuss because that's more in relation with raising money, finding shareholders and things like that, and that's not the aim of our discussion. And now the last thing I will tell you is that I've been using the words IP, but as you know, IP is a very general term, very broad term, and you have some IP for which you need registration. You have some IP as copyright where you do not need registration. When you, according to your activity, you may need to have patents, or you may need to have designs, or you may need to have copyright, or all of them. You always need to have trademarks, and you may also need, according to your kind of IP, to be able to use other less, let's say, less known IP rights such as GI or plant protection. So it's it's something which needs to be discussed on a case by case basis, but you need to be aware of all the
देखिए
kind
कभी
of
कभी
IP.
ऐसी गलतियां माफ भी करनी चाहिए बट कुछ लोगों की गलतियां इतनी बुरी होती है ना जिसको आप माफ नहीं कर सकते
Sorry, you need to be aware of all the type of IP existing that you can use, uh, and um, and finally, you need to be
मैं
careful when you
सात
think
आठ
about
बजे तक
IP.
कोशिश करती हूँ मतलब मेरा तो वैसे 6 बजे तक नॉर्मल लेकिन वो कंपटीशन के लिए
Sorry, someone is speaking, but so
Ms. Garima Swaroop, if you have any queries, you can type it out in the chat box for Mr. Herald to go through it. You may continue,
yeah.
please.
Yeah, okay. And last but not least, you need to be aware, and I already mentioned that if you need to protect your IP meaning by going to court, you may have to spend a lot of money, much more than the cost of registration. If you need to defend a patent in the US, we are speaking about potentially millions of dollars if you have to go to court. And obviously, very few startups, especially at the beginning, have this amount available. So therefore, be careful about what you are doing and why you are doing it, as long as you do not have the money uh, allowing you to protect your IP rights. And finally, two things. Keep a very good track of what everything you are doing when you develop something, to be able to prove to whoever court in the world that you did it and when you did it and how you did it. So try to use as much as possible the trade secret protection when it exists, and you can use that by um, uh, through contract agreement. And last but not least, do not forget before showing or discussing anything with someone who is a third party, to put into place a NDA, a non-disclosure agreement, and an NDA very well written, because you have lawyers and lawyers, you have NDAs and NDAs. So you need to find a good one, a good template, and you need to have it signed by anybody with whom you are going to speak, in order to be sure that you do not lose what is normally yours. So I'm ready, and I will be ready to answer to any question, but I'm sure that my colleagues on the screen have other things to add to what I said, and they know certainly much more than I do. Thank you for your attention.
Thank you, Mr. Richard, for your insightful speech. We appreciate expertise and knowledge you have shared with us today. So do we have any questions for Mr. Richard? You can type it in the chat box, so please raise your hands. Anybody? Do we have any questions? Okay, it seems that we don't have a question. All right.
Everybody understood everything or nothing.
All right, let's move ahead then. Mr. Richard, I can see that you've already shared the email address in the chat box. So if anyone in the audience has any questions or need further information, please reach out to him through the email address he has shared. Now, I would like to invite Mr. Amrit to commence his speech.
Good evening, everyone. All my respected colleagues. I first take this opportunity to thank Team SK Associates and Group. It's indeed an honor to be invited on this conference and to be speaking on such an emerging area. I'll be speaking on the aspects of intellectual property protection for startups, especially in the Indian context. And over the next 10-15 minutes, the idea would be to share with you the experience which I've had regarding both practical as well as academic experience in the context of this topic. So to begin with, what I would like to say initially is when we talk about intellectual property, and we see so many companies, especially the startup companies in the Indian sector, they are working on a lot of new technology which is available, a lot of important developments which we can say that might be revolutionary in the future, and companies have started working on it. So let me just give two simple illustrations for that. If we take the example of a company like Zomato, they started with the name Foodie, which was the original name for that company. But eventually they had to alter that name to Zomato because they feared legal repercussions from the company eBay. And Foodie and eBay did match up to some sort of similarity. So Zomato probably feared some potential legal consequences and had its name altered. Similarly, if you look at the company Ericsson, for example, who are into developing patents for smartphone technologies, intellectual property is actually a huge part of their business model. They do generate a lot of revenue from considering IP as an important component of their business model. So essentially, when we talk about these companies and so many more amidst recent history, the one thing which stands out is that intellectual property is to be seen not as something which over which you can create a legal protection on an asset, but rather a part of the core business model of whichever sector your startup is venturing into. So by that, what I mean is, let's say, for instance, that we have a hospital chain which is about to be set up in the country, and there could be dozens of companies who could be providing some sort of outsourcing to these companies, for example, medical devices, equipments, and any other related infrastructure. Now you need to have inventory for that, and most likely companies these days will opt for a digital inventory of some sort to maintain some uniformity and consistency in that area. Now, if you have a company in this sector, you would probably have a website, you would probably have some sort of content to be able to market to your respective audience. You would like to be frequently updated with the recent inventions and innovations, and especially you would probably create a software or some sort of a database to keep stock of the huge repository of information that you might have. Now, all of this takes a lot of work and a lot of time and effort on the developer's part. And one would not just give it away so easily to some other players in that particular industry. So that is where the importance of intellectual property comes up, because it's essentially protection of your creation, of your creativity, and it can also apply equally to startup companies just as much as it applies to any other big established corporation or an enterprise. Now, if you look in the Indian context, a startup is essentially defined by the Department of Industrial Promotion and Internal Trade, which is a department under the Ministry of Commerce, as an entity which could be a company registered under the Indian Companies Act 2013. It could be a partnership firm, or it could also be a limited liability partnership. And one of the essential conditions for being a startup is the company or the entity should be working in a novel technological space, which must be having some sort of industrial application, and the company must be of at least less than 10 years old after its incorporation. A lot of companies are presently meeting this requirement, and the government has tried to streamline this sector as closely as possible in accordance with India's ease of doing business initiative. And if you look at the national IPR policy of 2016, which was brought into force by the Indian government few years before, one of the key considerations which has been mentioned in that policy is the importance of intellectual property for startups. Now, what the policy essentially states is that intellectual property should not just be a claim or a protection over some sort of assets or any kind of creation or innovation, but rather it should also extend to being a critical component of the business model of that particular venture or that enterprise. Now, for startups, if you look, there are so many areas where this can make a valuable contribution. We are right now talking about things like, for for example, companies in the space sector, or for example, in the generative artificial intelligence sector, nanotechnology, quantum computing. So many emerging areas are coming up. And we have also instances from the fourth industrial revolution. So, for example, companies which are part of the third generation of the internet, what is also referred to as Web3, are also slowly and steadily emerging in the Indian jurisdiction. Now, eventually, one of these companies or a few of these companies will integrate technology at some stage as part of their business model of the company. And when that happens, that technology becomes a core ground to determine how competitive your business model can be. And that is why, even from a competitive point of view, intellectual property protection can actually augment an enterprise's business model and can do wonders for a startup if it is managed in the right way. Now, for instance, if I take the example of one of the companies in India's space sector, Bellatrix Aerospace is one of the companies in India's space sector which has done a really good job as far as developing space shuttles and other related infrastructure. They have also secured a lot of intellectual property protection in the form of trademarks and patents for their respective innovations and creations. But what is important for a startup is to know which kind of intellectual property protection can apply at what stage. Let's say, for example, that a company or any startup entity for that matter has developed its own website for which it has generated its own content. Now, as far as the content is concerned, it can definitely claim copyright protection. As far as the design of the website is concerned, the protection for trademark is also available. And likewise, if any sort of manufacturing process is there or any sort of application, industry based application is there, patents can also be a huge part of the IP portfolio of that startup company. Now, what is important is not just securing protection for these assets, which is, of course, a great way to monetize your business model, but also to be able to identify metrics or parameters as to how the same can be integrated into that enterprise's business model. Now, when this happens, as a result of this particular integration, the startup can ensure that at a competitive, from a pragmatic point of view, the startup is much more ahead of its competitors. And this therefore opens up a lot of opportunities for young corporate lawyers to be able to service these companies and secure their intellectual property protection. Now, as far as the initiatives are concerned, the government has also been very liberal with respect to startup registrations. And I'll just share a few examples of some government policy initiatives. The government has come up with something known as the Startup Intellectual Property Protection Scheme, under which, for innovations on different aspects like patents, for example, both product patents as well as process patents, manufacturing process patents, there is a relaxation where 80% of the filing fees and everything can be reduced for any entity which applies for intellectual property protection through patents. The same goes for designs as well, industrial designs. And likewise, there have been many other initiatives, like if we take the example of how the government has basically tried to make sure that any early stage enterprise through the startup seed funding scheme can secure funding up to rupees 5 crores under the existing policy which was created in 2021. And like this, so many new and upcoming policies are coming up where they are all trying to ensure the one common theme is that IP should not just be a part of your protection of intellectual assets which has been created, but also a core component of the business model, because that is one thing which will try to give a very strong competitive edge to any of the companies which are prevailing in that particular sector. But having said that, considering the fact that intellectual property protection is such a key thing because it offers you an exclusive right to protect your innovation as a reward for whatever hard work that has been put into for developing that unique product. But there can be some downsides to this also. And as more and more startups can claim intellectual property protection, and it becomes an established fact that eventually they would definitely scale their businesses very quickly. And so a lot of times what happens is intellectual property protection can also be misused, and this is frequently the case with a lot of sectors where companies can a lot of times scale up their business very quickly and can definitely use their intellectual property to generate some sort of an artificial entry barrier for companies to enter into that market. One such sector which in India and in many countries like European Union, US, for example, also this sector also sees a lot of friction between intellectual property and competition law. One such sector is the telecom sector, where if you look at some of the smartphone manufacturers or the chipset manufacturers, one such case happened in India before the Competition Commission of India way back in 2013 and subsequently after that also, where this company was actually having a portfolio of around 30,000 patents, but it was using it to create some sort of a structural entry barrier so that companies may not be able to enter into that space, and then they're licensing those patents at unreasonable rates. So that could be one downside to intellectual property protection if a company or if a startup entity for that matter tries to accumulate IP as a business model and thereby scale up its business at such a fast rate that it might create hindrances for other companies to enter into that sector. But having said that, this is one of those areas where you could say that intellectual property is more of an opening into the industry and not something which should be seen as a problem, because what I just described a while ago is basically something which is common among established companies which were small companies at one stage. But it's not necessary that all the emerging startups will probably engage in this behavior. And intellectual property, therefore, is also a tool in the hands of lawyers to enforce good corporate governance practices. A lot of times, what happens is companies will try to enforce their IP, but if you do not have a codified intellectual property management policy, that can also wreak havoc a lot of times when you're defending your company in a litigation or maybe starting on a litigation process. So from a corporate governance perspective also, what's very important is that you should have a dedicated intellectual property management policy which should be followed through a trickle down approach, right from the top of the management to the people who are enforcing that policy at some stage. It could be employees or any other stakeholders associated with the company, and they should be knowing what that policy speaks about and how that policy can actually be used to secure protection for the company's assets rather than generating some sort of unethical business practices. So from all this point of view, from this perspective, what can be said is that intellectual property protection no doubt is crucial for startups, but also at the same time a fine line of distinction has to be made between where to use it as a good ethical business practice and where to not use it as an unethical business practice. That would be all. Thank you so much.
Thank you, Mr. Amrit, for the wonderful speech. Do we have any questions for him? Anybody, raise your hand so you can write it in the chat box. Yes, Dr. Madhvi.
Hi, Amrit. Am I audible?
Hello, ma'am. Yes, ma'am, you're audible.
Thank you for that insightful talk. I just want to ask a question connected to the startup space. Uh, could you highlight the top three or five gaps?
Ma'am, I think one of the key things that it's important for identification, like I said before, was where do you know which kind of intellectual property protection is suitable for you. That's why one of the fundamental things that any startup entrepreneur should be knowing is essentially how to identify which kind of IP is suitable for what area. Like for example, if a company has a website and a lot of content is generated then in that situation, copyright would be the ideal method of protection. And if you have some sort of a symbol or name, trademark protection, any sort of manufacturing process or product that you have created, then patent protection would be ideal. And also, one of the other challenges which can occur at a lot of times is that if the startup does not have that much knowledge about the existing market and their competitors, then even if they have a good portfolio for intellectual property protection, that will not be a feasible idea to enforce it, because tomorrow some other competitor can come in. And these kind of cases are very common, where false intellectual property protection cases are also filed against big established corporations, and they just try, it's just a shakedown process for many companies. So you need to know what your market is, who your competitors are, and then you can maybe identify how do, as a company, how do we go about enforcement of our intellectual property protection. Because IPR is about basically two things. It's about intellectual property protection, but it's also about intellectual property management. So if the IPR management is taken care of, protection will also be taken care of as a natural consequence for that.
Thank you.
Thank you.
Okay, do we have any more questions? All right, let's move ahead. I can see you already shared your email address. I'll share it again for the new joinees. All right, if anyone in the audience would like to connect with him in future or has any questions, need further information, please reach out to him through the email address I've shared. Now, I'd like to invite Advocate Aram to commence her speech.
A very good evening, ladies and gentlemen. I'm deeply honored and privileged to stand before you today as a guest speaker at this prestigious international conference. The topic at hand, the impact of intellectual property rights in the emergence of a startup, is of paramount importance in today's fast-paced and innovation-driven global economy. Before delving into the subject matter, I would like to express my gratitude to the organizers for providing me with this platform to share my insights and knowledge on this critical issue. To set the stage, let us begin by understanding the significance of intellectual property rights in the context of startups. So, IP encompasses a wide range of intangible assets, including patents, trademarks, copyrights, and trade secrets and design. So these rights form the backdrop upon which innovation, creativity, and entrepreneurship thrive. So if I particularly talk about my own experience as a law practitioner, specializing in IP rights and how it intersects with the dynamic world of startups across various industries. So in this rapidly evolving landscape of entrepreneurship, startup plays a vital role in driving innovation, creating jobs, and fueling economic growth. So, as a specialized IP attorney, I've had the privilege of working closely with multiple startups across diverse industries. So, today I'd like to shed light on this critical role that IP right plays in shaping the success and sustainability of the startups. So, IP is a cornerstone of innovation, and it encompasses patents, trademarks, copyrights, trade secrets, and designs. For startups, safeguarding these assets is paramount. So, as they often represent the core value and competitive edge of the business, let me illustrate these with few key points. So, number one is patent protection. Startup often possess groundbreaking technologies or unique processes that provide a competitive advantage. So, patents are instrumental in safeguarding these innovations, granting exclusive right to the startups for a limited period of time. So, this exclusivity can be crucial in attracting investors, establishing market dominance, and negotiating licensing deals. Further, trademark or we can say branding. So, building a strong brand identity is vital for startups to stand out in the market. And trademarks protect a company's brand, logo, name, and allowing startups to distinguish themselves and establish trust with their targeted audience. A well-protected trademark is an intangible asset that can significantly impact a startup's market presence and valuation. Another one that is copyright. So startups often create original content, software, or designs that need protection against unauthorized use or replication. So copyright offers a robust defense, enabling startups to control how their intellectual creations are used and distributed. This protection is invaluable in maintaining the integrity of the startup's creation. The another one is trade secrets. So many startups rely on unique processes, formulas, or methods that constitute trade secrets. Protecting these secrets is essential for maintaining a competitive edge. By implementing proper contracts, confidentiality agreements, and security measures, startups can preserve their valuable trade secrets. Number five, that is licensing and collaboration. So IP right allows startups to leverage their innovations by entering into licensing agreements or collaborations with established players in their respective industries. And this can provide additional revenue streams and accelerate the growth of the startups. Moreover, in recent years, startups have emerged as powerful engines of economic growth, fostering innovation, generating employment opportunities, and redefining industries across the world. Their success, to a significant extent, depends on their ability to protect and leverage their IP assets. Therefore, it is crucial to explore the multifaceted impact of IP on startups. For instance, fostering innovations. So IP rights provide startups with assurance that their innovative ideas and inventions will be protected. This, in turn, encourages entrepreneurs to invest time, efforts, and resources into research and development, leading to breakthrough innovations that drive economic progress. The another one is attracting investment. So investors are more inclined to support startups that have a solid IP strategy in place. So IP acts as collateral, making it easier for startups to secure funding, which is often critical for their growth and expansion. The another one is the competitive advantage. So startup can use their IP to establish a competitive edge in the market. Patents, for instance, grant exclusive rights, preventing others from replicating their technology or product, thereby allowing startups to gain a foothold and capture the market share. The another one that is monetization opportunities. So, like we all know, IP rights open up avenues for startups to monetize their innovations. So they can license their technology, sell patents, or engage in strategic partnerships, creating revenue streams that can sustain and grow their businesses. The another one is the global expansion. So IPR protection extends beyond borders, facilitating international expansions for startups, and it enables them to enter new markets with confidence, knowing that their IP will be safeguarded. And last but not the least, that is protection against litigation. So startup can use their own IP to deter potential lawsuits from competitors or patent trolls. A strong IP portfolio can act as a shield, reducing legal risk and associated costs. So, in conclusion, I would like to say that like IP rights are not just legal safeguards; they are the lifeblood of innovation for startups. And IPR are a double-edged sword for startups. A comprehensive understanding and effective management of IP can be the catalyst for a startup's success, bolstering its growth, attracting investors, and ensuring a sustainable future. As we continue our discussion through this conference, I encourage you all to explore the practical aspects of IP rights for startups, share the best practice, and collectively work towards fostering an environment where innovation flourishes and startups can thrive. Thank you for your attention, and I look forward to engaging in fruitful discussion over the course of this conference. Together, we can shape a future where startups are empowered by the full potential of intellectual property rights.
I hope I'm audible clearly, Anjali.
Yes, you're audible.
Am I?
Yes, you're audible.
Thank you. you, Advocate Ram, for your informative speech. We appreciate your knowledge that you just shared with us. Please do share your email address in the chat box so that if anyone in your audience has any questions, they can reach out to you directly. Moving ahead, I would like to invite Mr. Karthik Ulala to come and share his
You are not audible, sir. You are not audible. Yeah, like your voice is breaking.
Okay, no issue. It seems like a network issue. I'll take over. Not a problem. I believe you'll have to rejoin. So, once. All right. Thank you, Advocate Ram, for your informative speech. Do we have any questions for her? Anybody? Okay, I'm sorry. Both of us have some network issues from our end. So, Ms. Advocate Ram, I would like to request to please share email address in the chat box. And if anyone in our audience has any questions or needs any further information, please reach out to her. Now I'd like to invite Mr. Kato Magula Latif to commence his speech. Mr. Latif, you can commence your speech. Yeah.
Thank you very much. I hope I'm able to do it. Before we become creative, I'll take this honor to present on the esteemed topic. My presentation is going to be entirely addressing the impact, of course, of the intellectual property rights on startups. Actually, I'll look at two sides of this subject, where the intellectual property rights are going to advocate for innovation and encouraging startups to bring forth their investments, and also looking at the other part of the competition, as other speakers have been speaking about, because with intellectual property rights, they look at exclusive enjoyment of the inventions of the inventors of a given invention. So first, looking at my speech, I'll look at the multifaceted impact of intellectual property rights on IPRs and startups. So first, we will my network. First, there are very many significant advantages that startups may have when they face challenges of IPR or intellectual property rights. So these are
Sorry to interrupt.
advantages.
Sorry to interrupt, Mr. Latif.
Sorry.
Would it be possible for you to turn on your webcam?
Okay.
Yeah.
I turn it off because of the network.
Yeah, that's fine now.
Okay. Uh, my discussion was on looking at the significant advantages of IPR or intellectual property rights on startups, and also the possible challenges associated with the same. With defending of intellectual property rights, we find that most investments are protected, and also the inventors of startups are, are supposed to be the sole beneficiaries of these invasions. So when we get to this instance, when startups are getting their financial burdens and they want to get more invasions, or they want to uh, anticipate their ambiguous future, when they have an intellectual property landscape that is in their favor, this risk is in most cases uh, mediated. So with the legal framework in Uganda, we particularly look at the very many startups which are coming up, because most people follow a given hype in a venture and start bringing up businesses. So when businesses from the start initiate with a trove of patents, and also with a broad and special with a broad registration of intellectual property rights, these safeguards help policymakers and regulatory bodies to ensure that the responsible startups or inventors are protected from various duplicities from the market. And it also encourages very many startups to start encouraging invention where they will benefit from whatever they've invented. I also speak about the other side where the former discussant has also tried to highlight with a level of competition. Remember, when intellectual property rights are protecting the inventors or owners of startups from competition or from duplicity or infringement, there is also an aspect of where it will leave a gray area of monopolistic behavior, where they will prevent innovation or people coming from that for many coming up in this in their sectors. So in this instance, when even innovation is prevented, because most people may misuse the IPRs, or may predict that this can cause lawsuits because of infringement of patents and IPRs or intellectual property rights. It will leave the environment less competitive. So it means when we are discussing the impact of intellectual property rights on the emergence of startups, we have to ideally look at how we are going to harmonize these two, where innovation is actually encouraged, and also competition is also put into play, where we prevent monopolistic behaviors, which are going to lead to less competitors in the given venture. So my discussion states that, of course, even if intellectual property rights have some disadvantages, but the side of the advantages is much wider, and it is presumably the best way of protecting startups by also encouraging registration of the various intellectual property rights on every startup. Thank you very much.
Thank you, Mr. Latif, for the wonderful speech. Do we have any questions for him? You can raise your hands or write it in the chat box.
I hope I'm audible, Mr. Latif. I had a question here for you. As you already elaborated that Uganda is actually expanding into a startup ecosystem. Is there any specific industry in Uganda that you would like to emphasize on which actually cannot operate without patents or similar intellectual property rights?
Thank you very much for your question. Yes, probably when you come to Uganda, we have the Uganda Registration Services Bureau, which tries to register every business. And when it comes to registration of businesses, I've actually handled very many registrations. But in the process of registration, there are very many companies that are barred from registering and carrying out their businesses legally in Uganda because these business ventures are a duplicate of another company that is already in existence. For example, we have WaveTech. This is a company that is entirely dealing with a software application where you can hire any manual or any laborers like cleaners, like laundry persons, like ordering a safe border or ordering a safe car. So this app has monopolized the aspect of making these deliveries and orders in Uganda because most other competitors who are coming up with the same business model are being barred from joining the trade because it has very many patents and trademarks which have been attached to its business model. And our legal framework does not address such circumstances. We are still looking for ways of applying the competitive law because in Uganda, particularly right now, we are still having a bill of the Uganda Competition Act, but it's not yet in existence. It means the players in the legal framework of Uganda have not yet been addressed with competition. They're still enjoying that monopoly. That's the challenge we're having in Uganda.
That was a great response, Mr. Latif. I would like to request you to kindly share your email ID in the chat box for any queries our attendees might have. Now, moving further ahead, I would like to invite Dr. Pankaj Kumar Agarwal to commence his speech and share his valuable insights with us on the topic. Thank you.
Thank you. Namaskar. I have few slides, so I'm thinking change the trend and so is it visible?
Yes, it's visible.
Okay, thank you. So thank you first of all to SK Associates and Group to provide me this opportunity to share my views and experience on IPR and particularly role of IPR in the emergence of a startup ecosystem and the challenge faced by startups in protecting IPR. So I'm not covering only the startups. This is all about the SMEs, small and medium enterprises, including startups and MSMEs. So we can say all startups are MSME, but all MSME may not be the startup. In India, we consider those MSME, the startup, those are DPIIT recognized certificates for this startup. So there are some advantage. Uh, Unfortunately, most of the small entities are not aware about the government schemes. There are so many government schemes for small entities, particularly MSMEs and startups, but very few are aware, and even after aware, there are very few such applicants who get the benefits due to lack of adequate awareness on such schemes. So let's move. So being a IPR facilitator, many times I experience such scenario. People ask, can I patent my trademark? I need to copyright my invention. So you
Sorry to interrupt, Dr. Pankaj. I think the slides are not moving.
Okay. So better I
Yes, it's moving now. We can see the second slide.
entire screen. I think that will be better. I think now it's okay.
Yes, it's fine now.
Okay. So this is this slide. Questions are very funny for IPR person. If anyone reached you to protect their mark under patent or invention under copyright, so first of all, we need to discuss the IP. What innovations or what creations the person having. Accordingly, we can suggest the appropriate IPR, like patent for inventions, trademark for their brand name, logo, whatever. Similarly, for artistic music, literature kind of things, we can suggest copyright. And for aesthetic appeal of any goods, we can suggest industrial design. So an idea can change your life. So there are some startups having success stories that they commercialize their idea well by expressing it and protecting it. So firms that own intellectual property right have on average 20% higher revenue per employee than firms that don't, as per the European Union IP office. So why it is important? So there are many reasons. One, it protects not only the key technology, but it provides the legal exclusivity to restrict other not to commercialize such intellectual property without the prior permission. And for such permission, they need commercial arrangement agreements like licensing, and it generates value. So other than that, commercial gain, it help to recognize, to get recognized such innovators, such authors, such inventors, and the companies, the firms, the SMEs, the startups. So this is the life cycle. Idea to successful business, there are some stages. We have to express our idea. So we need to create or innovate something which exists earlier. So we need to do some value addition. And after application, we can register it. And after that, we have to maintain it by renewal time to time. So it's very obvious that it needs a lot of time, energy, efforts to develop some intellectual property. So we have every rights to protect it. And unfortunately, due to lack of adequate awareness, many times uh, a small entity is unable to register it at the time. And once it's published in public domain, there is a problem of novelty, case to case. So there are many importance, like in academic scenario, plagiarism is the keyword in this respect. Many times, whenever we talk about research articles, theses, project reports from the researchers and the students, we take consider this issue. And other than this academic context, there are legal rights in scientific research, and every times there is no need of technological advancement. Even for economic advantage, it can be considered invention. So there is a list of importance and benefit of IPR, and in view of the importance of such IPR, different kinds of IPR, UGC recognize this subject in such a way that they wrote a letter to all the vice chancellor in India and requested to devise through academic council inclusion of the IPR as a generic elective subject under choice-based credit system, that CBCS scheme, in your esteemed university and the affiliated college. So this is the life cycle. Idea to create, and whatever the creation, we need to protect it, to monopolize, to exclude others. Further, we need to maintain it, and there is no any benefits of doing all such things if we fail to commercialize. Either we have to work or we have to give consent to other person interested by mean of licensing or assignment. So in India, this is the Office of Intellectual Property Office, generally known as CGPDTM, Office of CGPDTM, Controller General of Patent Design Trademarks. So this is the jurisdiction, but it hardly much importance because there is no any requirement to visit such offices, and most of the work is we do online. Even a hearing can be conducted online. So now many times people reach us and they are confused regarding their innovations, where how they can protect it, under which tool they need to protect it. So there are different types of IPR. As per the kind of intellectual property, we can suggest them the appropriate IPR. Again, many times people having some unique idea, they think that this idea can change their life. So what next? Generally, they discuss it with people, their friends, family, colleagues, and that time they lose. There is a risk of losing the novelty. And many times people publish their innovations and they risk, after getting appreciation from the friends and public, oh, it's a great work. Now we need to patent it. So there is a problem of novelty. They already put it in public domain, so it's published and they kill the novelty. So in order to motivate the scientist, earlier Director General of CSIR, Dr. R.A. Maselkar, told publish and perish, patent and prosper. We can publish even after patenting, but we can't get patent after publishing. So better publish, better patent and get prosperity by commercialization. But if we publish it before getting patent, then we can't exclude anyone. So generally patent protection is particularly useful for costly to invent, but cheap to imitate ideas. So we can consider only those kind of invention to get patent, which can be easily obtained through reverse engineering. And again, there are two expressions, NDA and IDF, non-disclosure agreement and invention disclosure form. So many times people are not much aware about disclosure agreement, particularly such small entities. So they discuss their inventions to anyone without doing any non-disclosure agreement. So there is a risk of sharing such precious knowledge in public and losing the novelty again. Similarly, in case of trademark, first come, first serve. Although there is no any compulsory requirement to get it registered, but it's very difficult to prove it prior usage. We need evidence. In case of inventions, we have options. Either we protect it under patent system, or there is another option, trade secrets. But again, we have to decide case to case whether we go for patent or we go for trade secrets, because there are some advantages along with some limitations. The term for protection for patent is 20 years, while in trade secret it depends how much time we can protect such confidential information. So it depends case to case. Again, in patent, we have a scope to publish our invention, but there is no such a scope in trade secrets. We can enforce our patent rights by claiming infringement, but in case of trade secrets, there is no any infringement suit, but there is a breach of confidence, breach of contract. So we can have to decide which kind of innovations we need to protect, whether it's under patent system or whether it's in trade secret system. So there is no need to manufacture and sell always by the same person who innovate or create. There is the option of technology transfer, by which our researchers can focus on their research and further research and innovations, and those commercial entities doing the same kind of manufacturing And trading, they can get the license or assignment from the right holder. So these are the options. Either the person can do joint venture or do licensing or do assignment. Again, licensing are two types, exclusive and non-exclusive. Exclusive license is just like assignment, but ownership is not transferred. So in case of patent, we need to remember few points like first protect, then publish. That means first we have to apply for patent, then we can publish it. Rights are territorial. Generally, IPR are territorial. Other than copyrights, most of the rights are territorial. We need to protect it country-wise. Although there are some system of international arrangement, so there is an international application, but there is no any international patent. Similarly, there are international application for trademark, but there is no any international trademark or international design. So registration is done by sovereign authority, that is government of that country. In case of India, there are IP offices under that patent office, trademark office, copyright office, design office, GI office, etc. So rights are for limited period of time. Case to case, it may vary. Like in case of patent, there is a 20-year from the time of filing or the priority, whichever is earlier. But in case of GI or trademark, it's for 10 years, but we can renew it further 10 years and so perpetually. So renewal need to be paid time to time in order to maintain such IP rights. There are so many schemes in India to promote a startup, MSME, educational institutions, all considered a small entities. So there is a 80% discount. So you can see after discount, the cost, this is particularly for patent. So a startup may get free professional services with patent facilitator. So other than this government cost, there is no need to pay any professional charges because such patent facilitator get reimbursement from the government directly. Similarly, in MSME, there are other schemes other than a startup SIPP scheme. Under that, MSME can get reimbursement up to 50 lakh to incubate their innovations, and such a scheme is called MSME IP scheme. So this is the certificate of recognition by Department of Industrial Policy and Promotion. So there is a provision of expedited examination and disposal of patent application. So using that path, startups may get patent grant or patent disposal in 6 months. So there are some cases where in 6 month time they get grant of patent, but generally it takes around 2 to 3 years, and in some cases even more. Earlier, there are many cases where more than 10 years taken by the patent office to dispose such applications. So the vision of SIPP scheme, that is scheme for facilitating a startup intellectual property protection, to protect and promote IP rights of a startup and thus encourage innovations. So IPR are emerging as a strategic business tool for any business organization to enhance industrial competitiveness. There is another scheme, WIPO Technology and Innovation Support Center, and there are around 10 TISC center in India, and this is an extension of SIPP. But the beauty of this scheme is, other than a startup, any Indian entity can approach this center to get free facilitation of IPR. So there is a panel, or the same panel can serve this and get reimbursement by the same method as under SIPP scheme. So this is a certificate which they need to get from the TISC, and based on such a certificate, they can get claim under the TISC scheme, that is the extension of SIPP scheme. And under MSME IP scheme, up to 5 lakh rupees reimbursed for foreign patent, and for domestic patent up to 1 lakh rupees, and for GI there is a 2 lakh rupees, and for design registration it's a 15,000, and for trademark it's a 10,000. So applicant here need to request online and they get a registration number. And after that, they get reimbursed it online. So this is one of the chat from one MSME client where he informed that he got payment from department, that is 10,000 for his trademark. And lastly, even academic institutions are also considered. They can get benefits under TISC scheme, so that they no need to pay any professional charges. And there is another scheme, that is Kapila Kalam Program for IP Literacy and Awareness. Under that, they can claim patent application fee and patent examination fee, the government fee, but they need to pay professional charges. So if they get benefit of Kapila scheme and TISC scheme, you see there is no any cost for patent to educational institutions. So both government fee and professional fee, they can get reimbursed. Thank you for your patience. So if you have any question, please feel free.
Anyone? Any questions you would like to put forward, Dr. Agarwal? You may please unmute yourself also. Questions? No issues. Thank you, Dr. Agarwal, for your informative speech and valuable contributions. Please do share your email address in the chat box. If anyone in the audience has any questions or needs further info, they can reach out to you directly. Thank you. So, as we come to the close of this remarkable conference, to be precise, to the close of this remarkable session of Conference 2.6, we would like to express our heartfelt appreciation to each and every one of you. The knowledge shared, the insights gained, and the connections made have all contributed to the success of this. We are truly grateful for your participation. As we wrap up this conference, we kindly request all attendees and speakers to take a moment, provide your valuable feedback and reviews on Google location of us by simply Googling us out. Your input and thoughts are highly appreciated as they will help us improve future events and continue delivering high quality content. Thank you all for your participation and for being an integral part of this session of Conference 2.6. We look forward to your reviews and hope to see you all in the last and final session of Conference 2.6 tomorrow. Until we meet again, stay inspired, keep dreaming, and continue to strive for excellence. Thank you. Have a great day.